Mr. President, the judiciary has shown consistently that it is the last line of defense for our country. It was thus with great dismay and embarrassment that I heard a person who has occupied the highest office of state, former President John Mahama, recently launched an unwarranted attack on the integrity of Ghana's judiciary. And I observed that this was really the latest installment of systematic and caustic attacks on our court by the former president, albeit unjustified. And I observed that this was really, and I'm compelled to comment on same in this address because they border on the security of the state and constitute a deliberate pattern of conduct aimed at undermining the independence of the judiciary, an arm of government whose autonomy is crucial to its proper functioning. Such conduct is clearly deplorable, coming from one who has occupied the highest office of president and aspires again to that office. At this moment, it is important for all to note that I express this sentiment not because I stand in opposition to former President Mahama as a politician. My dismay is founded more on the fact that I'm a lawyer, and every lawyer ought to be concerned about these kinds of views expressed by a political leader in this country. It would be a sore omission if I fail to recognize that there have been other leaders of the political party to which the former president belongs. I do not recall either the late Jerry John Rawlings or the late Professor John Evans Atta-Mills mount such a systematic and deliberate campaign of hate against the judiciary. In fact, never once did Professor Mills, Mr. Mahama's former boss, launch any attack at all on the judiciary. Closely examined, one will notice that the source of the former president's unjustified attacks on the judiciary is the unanimous dismissal by the Supreme Court of his rather porous election petition, which indeed, in my respectful view, was dead on arrival and bound to be dismissed by any court worth its salt in the country. One cannot fail to note that his petition before the court in 2021 was a bundle of incompetent claims devoid of any substance. As stated already, the allegations of wrong aggregation of votes and vote pardon, which he put before the court, collectively involved only 6,622 votes, a figure which could not in any way affect the outcome of the presidential election. It is therefore perplexing how, if such a petition is dismissed by the court, it should form the basis for an allegation of unfair treatment by the court. It ought to be understood that it is a duty of the court to administer justice according to law. The court is not a mercy chamber to serve justice based on sympathy or affection. I observed with even greater worry that the former president, who is a non-lawyer, made this comment at a meeting of the legal committee of his political party. None of the lawyers raised a finger to contest the wrong and dangerous propaganda by the former president. By their silence, they became abettors of the propagation of hate against the judiciary.